On June 11, 2026, officers were dispatched to a business at 4433 Briggs Road in regards to theft in Harrisburg, Texas. The complainant observed defendant leave with an unpaid merchandise. Defendant did not make any attempts to pay. Total value was $84.98. Defendant fled in a motor vehicle. Then on June 14, 2026, at the same location, the same agency did a traffic stop for a missing front plate and ID'd the defendant by her Texas driver's license. The victim identified the defendant through a mugshot. She wishes to pursue charges.
Where is this at? Please.
This is located, let me see if it says the name of the business, Judge. Custody address.
Ma'am, I'm gonna find that there.
City Trends, Judge.
What is it?
It looks like a clothing store.
What's it called?
City Trends.
City Trends. Ms. Brown, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to go back to the store whatsoever for any reason. I'm taking you in. Stop. Sir. Thank you, Riley. Ms. Brown, as a condition your bond, you will get a GPS monitor prior to release so that we know that you're not going to any locations involving City Trends. This is number, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, and now your 30th theft case. You are on felony deferred for theft. They've issued a warrant for your arrest, and now I'm taking you into custody. Prior to your release, you were not to go to any of the places alleged. Otherwise, I will make your bond extremely high. Do you understand, Ms. Brown? She goes with you. There is an open felony warrant for your arrest, ma'am. Victoria, do you mind appointing her lawyer, please? Okay. So don't worry about filing conditions because we'll have.
They call that MA.
Yeah, I saw. Okay, counsel, you ready?
We're waiting on the interpreter.
Wonderful.
Good morning, Judge.
Good morning. You ready, Tony? Come on. Let's rock
On the
and
spot, John.
right.
Judge, bottom of 1, top of 2. Alonso, come on up.
Good morning, Your Honor.
Good morning. Thank you for coming. You were Miss Alonso.
Yes.
Ma'am, you're charged with 2 counts of cruelty to non-livestock animals. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On April 22nd, 2024, HCSPA went to the residence and spoke with Marilyn Morales, who is the daughter of the property owner. The report was of a dog with an embedded collar, and the caller who had reported it stated that they had removed the collar and observed open wounds on the dog. The caller reported that the second dog was tied up without food, water, and shelter. There were dog houses, but they weren't being used for the
I'm
dogs.
sorry, there was.
Dog houses. Upon approach, officers were met by the pet with an AID 545-593, who was unrestrained in the fenced yard. The dog had an open wound around his neck and was lean and muddy. They spoke to Morales, who confirmed that that dog had an embedded collar and did not think defendant had sought a vet for either dog. Officer spoke with defendant on the phone. They found the other dog, AID 545-594, tied outside with a short tangled rope and scarring around the neck. Pet with the ID 545-594 was thin and had a distended abdomen. Two dogs with ID 545-593 and 545-594 were surrendered. Cruelty exam showed that the one ending in 594 had extreme heartworm disease, upper respiratory infection, gastroparasites, and conjunctivitis. Officers also found a horse with ID 595-772 and spoke with the defendant. The horse was colicked a few weeks ago.
I'm sorry.
It says
Unas semanas atrás.
he got meningitis.
The horse had meningitis.
Yes.
And that she had not provided vet care for the horse. The horse was severely lame, could not walk to take a step, and muscles, trophy of muscle on hind limbs, severe founder in all four limbs, and pressure sores.
Do they take custody of the animals? Do you know? Of all of the animals?
So they did surrender the animals,
Okay,
and that they have all the animals.
all right. Ms. Alonso, I'm going to find that there's sufficient probable cause to go forward in both of your cases. As a condition of your bond, I'm ordering you not to be in care, custody, or control of any animals whatsoever. This includes a dog, a cat, a goldfish. I don't care what it is. You have an animal, I will revoke your bond and put you in jail. I don't know what your immigration status is, but if you go into custody and you're not here with proper permission and immigration finds you, they may very well put a detainer on you and you could spend many months in custody. There will be no more warnings for you. Do you understand?
Yes.
For now, we will have you sign a reset. I will have you take a seat in the jury box while we get your bond conditions. Once you have them and sign them, at that point, you will be free to go.
Thank you.
It does have bond conditions. We just wanted to confirm that they were okay with the court. It's appeared to court every time, no new law violations.
Okay, I see it. That's sufficient. I think that's sufficient. Yep, that's sufficient.
And we have done a reset on it.
Great. So they're free to go. Victoria. They're good to go. Okay, please.
Thank you, Judge.
Thank you. Hi, are you ready?
Judge.
Hi, Randy. What's up, man?
How much you doing, right?
Yeah, talk to me. Who you got?
Mr. Zapata?
Do you need a translator?
No.
Page 21, Judge, go ahead.
Do you mind bringing them up?
Oh,
Judge states law.
No, it's conditions already done, so she can go. All right, Mr. Zapata, you're charged with driving while intoxicated. You speak English, correct?
yeah.
You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Officers were dispatched on July 3rd, 2026, around 1:56 PM to 1300 block of Gillette Drive in Baytown, Harris County, Texas, in reference to a major accident rollover, a single vehicle crash. Officers were told by dispatch that the driver fled the scene, running southbound through a public park. The driver was described as a Hispanic male wearing a black shirt with blue jeans. Upon arrival on the scene, they observed a white 2020 Chevrolet Camaro with the license plate XXY 1509 that was upside down and had a wooden light post in front of it lying on the ground. Officers checked the vehicle registration and it returned to the defendant. While investigating the accident, the driver, which is the defendant, returned to the area approximately 400 yards east of the scene, which was a large open field. The defendant brought himself back near the scene. He was detained by officers. The defendant was matching the description that was provided by dispatch and had the keys to the Camaro and admitted that it was him driving the Camaro and that the accident was his fault. The defendant stated he was driving in the public roadway trying to get back home. He explained he was coming from a bar and was trying to head back home. Officers noticed his speech was delayed and there was a slur. The defendant's eyes were glossy and red, and there was an odor of alcohol emitting from his breath. Due to the severity of the accident and a high possibility of chance of head injury, officers did not do standard field sobriety tests in fear of the injury impeding the test. Based on their training and experience, they did believe that the defendant was intoxicated, so he was taken into custody. There was a picture provided of the defendant crawling out of the vehicle before he fled the scene. They were able to identify the driver exiting the vehicle as the defendant.
Did you say there's a picture?
Somebody provided a photograph of the defendant leaving.
Okay, interesting.
Officers explained, Judge. The vehicle was inventoried. No alcohol was found in the vehicle. Officers did read the IC to the defendant, who consented to a blood draw. Baytown Fire EMS drew blood from the defendant at the Baytown Jail, and we're pending a search warrant results.
Any prior DWI license? Does he have a license?
Don't see any criminal history, Judge. I'm not even no.
Mr. Zepeda, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. It's not a matter of if, you will be tested. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain car insurance, and that is also a condition. If you don't have it, then do not drive. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel. If he tells him he cannot get a hold of you, then likewise, I will revoke your bond. Do not pick up any new cases. You understand? Okay, we'll have you sign a receipt. You guys are good to go. He'll need to get with preach on this one. Yay or nay? Wait, Randy, he doesn't have a license.
I think if the one that shows up is a personal ID card number.
You don't have a license. You are not allowed to drive. This is an affidavit that you're going to sign with me today, promising me you're not going to drive, Mr. Zepeda. I don't give a rat's behind what your excuse is. I don't care that you have to go to work. I don't care that you got to go to school. I don't care that a bunny has to go to the hospital. You drive. I can have a contempt hearing, and every time up to 180 days in jail and a $500 fine. You drive 5 times, I can have 5 contempt hearings. Do you understand? If you want to drive, go get a license, a Texas driver license, get insurance, and we can talk. But until that point, you drive, your butt's mine. You understand?
I just want to make sure there's no alcohol in the gas, random analysis.
Yeah, but I'll have, she'll do the conditions.
Okay.
Yeah, so for monitor, she'll do the conditions. All right, come on up, Mr. Zepeda. We'll have you swear to us that you're not going to drive, get you to sign a reset, and your conditions, you're out of here. Thanks, Mr. Yates.
Baldwin, top of the freezer.
Got it. Thank you for checking.
Yeah.
You are, is it Bayon?
Ball.
Oh, top, I'm sorry. All right, Mr. Baldwin, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Yes, Your Honor. Around 1:53 in the morning on July 5th, 2026, officers conducted a traffic stop on a silver Jeep SUV driving westbound in Harris County, Texas, with no license plate lights. Officers made contact with the defendant, who was identified by name and date of birth. The defendant provided a Texas ID card and was found to have multiple municipal warrants from different agencies while operating a vehicle in Sam Houston Parkway. The defendant also had a driver's license showing not eligible. Further review found that the defendant was operating the vehicle and failed to fill proof of financial responsibility. Subsequent check via Superion showed that the defendant had previous convictions for driving while license invalid and failing to maintain financial responsibility on a motor vehicle.
Mr. Baldwin, I'm going to find that there's probable cause to go forward with your case. The exact same thing I told the other gentleman applies to you. You'll be signing an affidavit promising me you're not going to drive. I don't care what you have to do in this life. You drive, I can have a contempt hearing, and every time 180 days in jail and a $500 fine. Do you understand me?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. I will swear to us, you're going to swear to us that you're not going to drive, and then we'll get you out of here. When you come back, please have a lawyer.
Castro. Bottom of 4 here.
Got it. And you can just send him on his way. Okay, Jay? Good morning, Ms. Castro. It looks like do you have a lawyer? Do you know if the lawyer's going to be here today?
Yes, sir.
You want to wait for your lawyer to get here? Okay, just go ahead, take a seat. We'll wait for you. It's,
Jorge Gallardo.
yeah.
Chavez. Top of 5, Judge.
Morning.
Hey, after this, give me 2 minutes because I need to talk to Keeling. Okay. Mr. Chavez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 4th, 2026, in Harris County, Texas, officers conducted a traffic stop at around 12:01 a.m. Due to the vehicle driving at a high rate of speed, the officer saw the defendant make an unsafe lane change, almost striking a vehicle to his passenger side. Officers drove behind the vehicle and observed it to be traveling more than 90 miles per hour in a 60-mile-per-hour zone. Officers initiated a traffic stop near the Gulf Freeway, approached the vehicle, made contact with the defendant, noticed a strong odor of alcoholic beverage coming from his breath. Officers observed the defendant to be slurring his words and had red glossy eyes. Officers conducted standard field sobriety tests. The defendant admitted that he had 3 beers to drink that night. The defendant had 6 out of 6 HGN. Officer again asked the defendant how much he had to drink. The defendant stated he had 5 beers the second time around. Officers observed 3 out of 8 on the walk and turn and 2 out of 4 on the one-leg stand. Officers placed the defendant into custody, read DIC. The defendant consented to providing a voluntary breath specimen, which came back to 0.099 and 0.097.
Okay, any prior DWIs, license?
I do not see any criminal history, Judge.
Okay,
I do not see a driver license number listed. He is 21 years old. And I'm trying to see if I can.
Mr. Chavez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. You do not have a license. You are not allowed to drive. Do you understand? Just like the other two, you will be signing a promise with me today. This is an affidavit.
I do, he did have a license number there, but when I ran his name, it came back to a driver's license number. That does expire in 2032.
So there you see a valid license.
Yes.
All right.
That it is out.
You may continue to drive as long as you have liability insurance in your name. You must have car insurance. That is also a condition. If you don't have it, then do not drive. How old are you, sir?
21.
How do you support yourself?
Work, construction,
And what kind of money do you make a month?
with 4,000.
We are going to reset your case, give you time to hire a lawyer. You're not going to qualify for a court-appointed lawyer. So what I'm going to have you do is I'm going to have you sign a reset. You'll get with Veronica for your bond conditions. After that, we're going to let you go. When you come back, please have a lawyer. Okay? Come on. Hey, Day, can I talk to you real quick? Keely, I don't want you to have to wait for the next 2 hours, so I'm going to talk to you now.
Okay, thank you, Judge.
Yeah, for sure. Hey,
I can fix that. The Zoom.
no, it's okay. But hey, we're not going to be long, just so you know, okay? For what it's worth. Hey,
My judge.
so she's asking to be withdrawn,
Yes.
but I don't know if that's a good idea until he gets picked up. And at that point, maybe withdraw.
Well, I mean, for what it's worth, I'm not opposed. The First Court of Appeals issued the memo yesterday, so his
Sure.
appeal got denied.
Right.
Sure.
Whatever they want to do afterwards. If he wants to-
Can I just keep you on until he gets picked up and then we'll withdraw you? So it doesn't look like
Yes,
it's
Judge.
Jay without a lawyer?
Yes, Judge, that's perfectly fine. There are some grounds on which I wanted to be heard for the withdrawal, but if Dave believes that he will get picked up today, I don't mind staying on until today or until, the following business day, Monday. I'm sure he'll get picked up over the weekend.
No, right now he's not eligible because the memo came yesterday, but the mandate still hasn't come down from the First Court of Appeals. So until the clock runs out, he's still told. And I don't know what he wants to do.
How long does it take to get mandate again?
I don't know. That's up to the justices.
Judge, can I make a suggestion? I'm currently out of town, but I will be back in town this evening. I would like to meet with Mr. Theriot. I believe that his only avenue at this point is a PDR, if any, but I want to talk to him
Right,
about
right.
that.
I mean, I
We
would
really
think that
can't,
that's,
And
after that, I mean, theoretically, federal court,
Technically, the
yeah,
US
so
I mean, and
I'll-
we've had people, Ramona, how long does mandate take? Do you know? Normally? You muted.
Sorry, Judge, I have no idea.
What about a governor's warrant? No?
Like, that's all pertaining to the writ, because for the governor's warrant, you've already issued the order. It was his writ of habeas that came from the order that it's being
Okay.
appealed and contested.
You can call and
I guess
find out,
You
Judge.
want to roll till Monday then? Keely?
okay, Judge, Monday is already looking very, very stacked for me. Could we do a week from now, Friday?
Wait,
Oh.
I'm leaving.
Do you think it,
Well, all right, I'm out for like a week and a half, right? So I won't be back
Dave-
until the 6th,
What day are you leaving?
Dave, when are you leaving?
Wednesday.
Okay,
Does that mean you're working Wednesday or you're
No, if
leaving?
I zoom from this vacation, my wife will kill me, so no.
fair enough.
Right. please don't.
My friend wants to murder me too for zooming in while we're
Yeah.
on this.
Hey, how
on
about
the-
Tuesday?
While we're on this
Can you do
trip.
Tuesday, Keely?
Yes, I can do Tuesday. It's going to be very stacked, but I will be there Tuesday, Judge. And this will give me an opportunity to meet with Mr. Theriot, see if he wants to move forward with a PDR or what he wants to do, but.
You
I may just be
can meet with him here and talk with him here so you don't have to go to the jail too, Really?
Yeah. No, I understand, but I'm not there now, and I would like a good opportunity to
Sure.
meet with him and
Okay,
talk to him.
all right,
for
so
a while.
Tuesday.
So just because we're not on the record right now,
Shh.
just to clarify, because he filed a handwritten writ again, because you're representing him, I'm setting that aside because legally you haven't issued it, or you haven't filed anything. It's just him. So just letting you know, like,
Right.
he had filed another writ. Okay.
Yeah, I understand. And
Okay.
that's one of the grounds on which I wanted to withdraw. We just cannot agree on the route that we want to take on this, despite me meeting with him previously in jail. We'll approach again on Tuesday, Judge.
Okay, all right,
Thank
all
you.
right, thanks.
Thank you, Judge.
All
I
right, thanks,
appreciate you
Keely.
accommodating.
Have a great weekend.
Bye, Judge. You as well. Thank
Do we have any lawyers there? Lawyers, anyone want to approach on PC? Or,
Those are here for arraignments.
I mean, arraignments, yeah. Anyone? Anyone? Come on up.
Henry Blanco.
What's the last name?
So you just
Oh, that was the next one coming.
Okay, Climaco, come up.
Did you file an attorney birthday?
Yes, we're attached.
Oh, okay.
I see it, yeah. All
Yeah.
right, good morning, Mr. Climaco. Sir, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Officers were dispatched in regards to a male subject wearing a black shirt, black shorts, shooting a firearm near the south side of a complex near the dumpster in Harris County, Texas, and Cherry Lane. The reportee advised that they observed multiple people, but that only one male subject had a firearm. Upon arriving in the vicinity of the south side of the complex, officer observed the multiple suspects, with three of them matching the description of the male subject wearing the black shorts and the black shirt. I instructed the three subjects to walk towards me and asked if they were armed, which they stated, two of them stated that they have firearms on their person. One male subject, who was initially observed holding an alcoholic beverage, later identified by Mr. Rodriguez, had a 10 Glock 19 on his person with 15 bullets inside a holster. Mr. Rodriguez was observed to have red watery eyes and odor of alcoholic beverage and from his breath of person. The second male, identified as Mr. Climaco, this defendant, had a black Taurus G3 bearing 18 bullets inside a holster on his person. Henry stated this defendant stated that he had discharged a firearm and was the only subject who did so. The defendant stated he discharged a firearm near the south side of the fence in the vicinity observed by the original reporter. Officers located 102 shell casings on the ground in that vicinity where the defendant stated he had discharged a firearm. 89 of those found casings with the same brand and ammo that was loaded in the magazines of the firearms located on the defendant and Mr. Rodriguez's person. It should be noted that the original reporting was not on scene when officers arrived. The two firearms in the shell casings were logged into the property.
Did they confiscate the weapon? Oh, you said they did?
Yes, sir.
Okay. Mr. Climaco, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons. If I find that you do, I will revoke your bond and put you in jail. No more PR bonds for you. You understand? Okay. We'll have bond conditions created for you to sign. For now, we'll have you sign a reset. I will have you take a seat in the jury box. We'll get your bond conditions. Once you sign them, at that point, you'll be free to go, sir.
Standard.
No weapons.
Gotcha. Thank you.
All right, Judge, next is top of 7, Davis. And co-defendant on page 8, Felton. Come on up.
Davis and Felton, come up. All right. Move on.
Oh, they're not here, Judge?
Nope.
Okay, bottom of 7, Demetrio.
Demetrio, come up. Looks like there's a co-defendant.
Yes, co-defendant on page 18, Velasquez.
Come up. Speak English, sir. Mr. Demetrio, you're charged with displaying a fictitious license plate. You're facing up to 6 months in jail and or a $2,000 fine. And you are Miss Velasquez. Ma'am, you speak English? You were charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause on both of your cases. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 2nd of 2026, officer observed a motor vehicle on a public roadway do the following traffic offenses. He observed it cut in after passing, failed to signal lane change twice, and have a deceptively similar license plate. The officer conducted a traffic stop and smelled a strong odor of marijuana The passenger stated the marijuana was hers. And the defendant had previous stops for a fake license plate and tampering with the government document. The other defendant also admitted to buying the license plate off of Amazon and putting it on his vehicle. The officer conducted the search and found a large brown bag under the passenger seat on top of a rolling tray, and inside the brown bag was 2 bags of marijuana with 41 grams. Defendant again said it was hers.
Okay. I'm going to find that there's probable cause to go forward on both of your cases. I need to know if Mr. Demetrio has a license. I don't think you can do that.
It's eligible, Your Honor.
Okay. Mr. Demetrio, we are going to reset both of your cases to hire a lawyer. I'm not putting any conditions on either of your cases. Do not pick up any new cases. Don't be a danger to my city. If you are, it's just not going to go well for you. You will not get multiple PR bonds. This is not a revolving door. Do each of you understand? Okay, we will have you sign a reset and we'll get each of you out of here, please.
Your Honor, just to be clear, that license is restricted to driving to and from DUI courses, if that matters.
Whoa, no. All right, Mr. Demetrio, come up. So does he have a license to drive?
He has a license to drive, but it has a restriction that he can only use it to get to and from DUI courses, is what it says on.
Does he have an open case right now? Or what kind of criminal history does he have? Do you see a,
I don't have a Harris County, I'm gonna run the Howard County right now. Your Honor.
From what I see, it's looking like it's extensive with multiple burglaries and motor vehicles. There's a DWI on here also. Forfeited room documents.
where's all this from?
Multiple locations around.
So Grand Prairie, Your Honor, is the DWI.
Okay, is that from 2010 or from recent?
2000, yes, Your Honor, I'm still going.
There's something in Dallas also. Bakers.
How do you know about that restriction?
There's a Dallas, there's a DWI out of Dallas, Your Honor, 2013.
Okay, she's gonna be monitored with you.
There's a reckless driving on here also. From 2021. And multiple forging licenses.
Sure. Mr. Demetrio, I'm going to find that there's probable cause you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond. It's not a matter of if, you're going to get tested. If I find that you're using, including marijuana, then I will put you in jail. At this point, I'm ordering you not to drive unless you have all valid documentation, including license plates, registration, and insurance. Do you understand? Okay. We're going to reset your case to give you time to hire a lawyer. I'll have you go sign a reset. You'll get with pretrial for your bond conditions, and then we'll get you out of here.
All right, Judge, next is top of 8, Duhart, and page 11, Preston, come on up. Go ahead. Go around. Okay, ready?
This is not appropriate dress for court, ma'am. Come on up. When you come to court, please dress appropriately. This is not the club. All right, Ms. Preston, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. And Mr. Duhart, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause on both of your cases. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 4th of 2026 in Harris County, Texas, an officer observed two motor vehicles traveling at a high rate of speed. The officer paced them at 96 miles per hour, but both motor vehicles were still pulling away from the officer. The officer conducted a traffic stop and noticed a smell of marijuana in defendant 2 Duhart's car. The officer conducted a probable cause search and found a loaded Glock 17 firearm located where defendant number 1 said it would be. There was also a small residue.
Okay, what's her,
Hers is reckless driving.
right, but what was it? You said, what's the reckless driving?
Speeding. It was going 96 and that's it. The officer facing the 26.
In a what?
I don't know. I'll have to check that.
That's a problem.
Yeah. Not sure. It says Interstate 45 freeway. Sure.
Mr. Duhart, I'm going to find that there's probable cause to go forward with your case. While this case is open, you're not to be in possession of any weapons, and that is your bond condition. If I find that you're in possession, then I will revoke your bond and put you in jail. You are not allowed to drive unless you have a valid Texas driver license and liability insurance, and both of those are also conditions for you. If you drive and you don't have either, then likewise, I will put you in jail. There'll be no more PR bonds for you. Do you understand? So he was also, you're saying, at that speed as well.
Yes. I don't know why he wasn't charged with reckless driving. I actually asked about that.
Also a condition, you're not allowed to drive in a reckless manner. No racing, street takeovers, donuts, anything maniacal. Do you understand? All right. And Ms. Preston, I'm going to find that there's probable cause to go forward with your case. Your only condition is you're not allowed to drive unless you have a valid Texas driver license and liability insurance, and not to drive in this manner again. If you drive in a reckless manner, I will put you in jail. Then I will take both of your ability to drive away from you. Please do not. You understand? Okay. Ms. Preston, we're going to reset your case to give you time to hire a lawyer. I'm going to have you go sign a reset. We will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go, ma'am. Please. Mr. Duhart, how old are you, sir? Okay, what do you do for a living? Okay, we're going to also reset your case, give you time to hire a lawyer. I'll have you sign a reset. We're going to wait on bond conditions as well, and then we'll have you take a seat in the jury box. Please.
Jackson, top of 10.
Hey, Karina, on those two, can you file, I don't know who, I need bond conditions filed, please.
Yes.
That's Preston and Duhart. No weapons, no
Preston,
and Duhart.
no weapons.
No reckless driving, racing, street takeovers, no driving without a Texas driver license or insurance. And I think that's it. Please.
Take a
Thanks.
vote. Deb.
Yeah.
Jackson on page 10.
All right, Ms. Jackson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 4th of 2026, officer dispatched to a target in Harris County, Texas at 21515 Poundville Parkway in regards to a theft. The complainant, loss prevention officer, had the defendant detained for stealing $160.39. The LPO stated the defendant entered the store and selected several pieces of children's clothing and concealed them inside her purse. The complainant stated he maintained constant observation of the defendant as she proceeded past all points of sale and exited the store without purchasing the concealed items.
Okay. How much was it again? What'd you say?
$160.30.
All right, Ms. Jackson, I'm going to find that there's probable cause to go forward with your case. You're ordered not to go to any target for any reason. If you violate this agreement, if you pick up new cases, I will put you in jail. No more PR bonds for you. Do you understand, ma'am? Do you have the ability to hire a lawyer? Are you working at this time? What do you do for a living? How do you support yourself? How many children do you have? Okay. Deputy Williams will give you an application. I need to know everything about you to see whether you qualify for a court-appointed lawyer. Don't just put zeros. Otherwise, I'm going to send it right back to you. We're going to have bond conditions created for you to sign. Do not leave until you sign the bond conditions. Okay? All right, please.
All right, Judge, top of
So I need
12.
bond conditions on her as well.
Wednesday,
No going to Target.
That's great. Yeah.
Jackson, no Target.
Second.
Thank you.
top of 12, Judge.
Great, thanks. Hi, good morning. Are you Mr. Reckaway?
Yes, sir.
Great, thank you for coming. All right, Mr. Puente, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You speak English? We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney. If you cannot afford one, one will be appointed to you, sir.
On July 4th of 2026, at approximately 9:08 in the morning, officers dispatched to a major crash at 1901 Goodyear Drive in Harris County, Texas, on a public roadway. The witness stated that he was the owner of a business at 1901 Goodyear Drive and that he heard a loud bang and ran out and saw a white Silverado truck had run into his fence located on the north side of the building. The witness stated he went over there and saw the defendant, who he identified as Jonathan Puente by the Texas driver's license, with the person behind the wheel, and came out of the driver's side of the white Silverado that had crashed into his fence. The witness stated he had seen the defendant come out. The witness stated he had seen the defendant inside the pickup truck and attempting to turn it on to flee the scene. Mr. Gutierrez attempted to take away the defendant's vehicle key to prevent the defendant from driving away. The officer noticed that there was one empty 187 milliliter buzzball container, which is a highly alcoholic drink, in the vehicle, and one that had been tossed out of the vehicle.
At 9 in the morning.
9 in the morning. The officer arrived, the defendant was still sitting behind the wheel. He noticed a strong odor of an alcohol beverage, slurred speech, an unsteady balance when standing or walking. The officer asked the defendant to perform SFSTs, and the defendant refused to perform the sobriety tests. Therefore, the officer read the DIC form and offered the defendant an opportunity to provide a sample of the defendant's breath, and the defendant declined this as well. The officer formed the opinion that the defendant was intoxicated and lost normal use of his mental and physical facilities, and drafted a warrant for the blood.
Mr. Puente, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you, as a condition of your bond, not to drive any vehicle that's not equipped with an ignition interlock on it. I'm also giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will be required to blow at least 4 times a day to prove to us that you're not consuming alcohol. If you refuse to blow, if you skip a test, it's like blowing hot, and your bond can be revoked, and you will go, or you could go into custody. Do you understand me?
Yes.
There will be no more PR bonds for you. This is not a revolving door. You are not allowed to drive unless you have a valid Texas driver license and liability insurance. And I'm now, for any car that you're going to drive, it must have an interlock on it. We send notice to DPS in Austin so that every police officer in the state knows it. They pull you over, and whatever car you're driving doesn't have an interlock, they will take you to jail. Do you understand?
Your Honor, also he's 20 years old.
Yeah, I saw that. We're going to reset your case to give you time to work the case out. Mr. Puente, I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it, because if you don't, I will address it for you. And I promise you're not going to like the way that I do it. You understand? Okay, come on. Counsel, I'm going to pay for all the devices for him so that there's no expense for him. But please admonish him if he skips a blow. It's just, all right? Okay, thanks. You got it.
All right, Judge, bottom of 4. Castro, come on up.
Hi, you ready? Good morning. Hi, good morning, Ms. Castro. You're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 3rd, 2026, officer observed a motor vehicle on a public roadway in Harris County, Texas, failed to maintain a single lane as well as pinging back and forth inside its own lane. The motor vehicle also failed to signal a lane change. A traffic stop was conducted and the officer noticed red bloodshot eyes, strong odor of alcohol from breath, and defendant admitted to drinking a tall Michelob. The officer conducted FWCs and there were 6 out of 6 for the HGN, 5 out of 8 for the walking turn, 2 out of 4 for the one leg stand. The DSC was red and the blow was 0.251 and 0.258.
2.5. Does she have any prior DWIs? Does she have a license?
It's not.
No prior DWIs, Judge, let me double check the eligibility of the license. She does have a license number.
You just know it's eligible? Yeah, okay, Mrs. Castro, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. You're going to get tested. It's not a matter of if. If you test positive, it's just not going to go well between us. Do you understand? Do not use. I know it's the summer. I don't care what kind of barbecue. I don't care what kind of party it is. Just don't use.
It is eligible, Judge.
All right. Likewise, you're not allowed to drive unless you also have liability insurance in your name, and that is also a condition. We'll have you sign a reset. You'll get free copy of your bond conditions, and after that, you're free to go. Please.
Thank you, Judge.
Thanks, guys.
All right, Judge, next is page 12, 0, and page 14, Sanchez.
Okay, who is Kuros? Okay. Both of you are charged with theft. Both of you are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to each of you.
Officer dispatched to a target in Harris County, Texas in regard to a call from loss prevention. The complaining witness observed the defendants enter the store and conceal unpaid merchandise inside their bags while walking out the store. The defendants exited the store passing all points of sale. $212.93 was recovered from Heidi Sanchez and $212.93 was recovered from Heidi Sanchez and $231.93 was recovered.
So each of them were seen concealing merchandise. Okay. Ladies, I'm going to find that each of you, that there is probable cause to go forward with your cases. As for both of you, as conditions of your bond, you are not allowed to go to any target for any reason. Do not pick up any new cases. Otherwise, I will revoke your bond and put you in jail. Each of you understand. You guys have the ability to hire a lawyer. Okay. Are you working at this time, ma'am? What do you do for a living?
A server.
A server. And ma'am, what do you do for a living? Okay. What are you going to do? You're 20 years old. What are you going to do for the rest of your life? This is not a good plan that you have right now. You're going this way, which is nowhere. You're 20 years old, really. At 20 years old, most people have a plan of what they're going to do, whether they're going to school, they're going to. It's time for you to do something. You must either get a full-time job or be in school full-time. Do you understand, ma'am? Okay. Deputy Williams will give each of you an application for a court-appointed lawyer. I need you each to fill it out. Do not pick up any new cases. Do not endanger my city. Do each of you understand? Okay, come on. No target, please, on both.
All right, Judge, next is page 13, Ruiz. Come on up.
All right, you are Mr. Ruiz. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On July 4th of 2026, I walked into a holding cell for an arrest of an AFM and unlawful restraint. The defendant said he was a gang member affiliated with Pango Blast and said he wants to handcuff him taken off. You can beat the officer's ass.
Oh, I'm sorry. Yeah, you are also charged with unlawful restraint. I just noticed that on that one, you're also facing a year.
And they did it multiple times. And then also for the other one, for the AFM, the complaining witness and defendant have been in a dating relationship for 5 years and are living together. The officer dispatched to assault in progress. Upon arrival, complaining witness stated a verbal argument occurred and complaining witness headed to leave. While packing, the defendant grabbed the complaining witness and tossed her around the room and slammed her into the closet door. He then forced her into the closet, preventing her from leaving. The complaining witness exited the closet. She observed the defendant banging his head on the bedroom door and yelling, escalating her fear. As she attempted to leave, the defendant blocked her path, slapped her across the left side of her face, causing pain, and again grabbed her and dragged her back into the bedroom. This continued for approximately 10 minutes until she was able to flee the apartment and call police. The complaining witness had visible red markings on her forearm, bicep, and left side of her face, and appeared emotionally distressed.
What happened to felony retaliation, please?
Felony retaliation?
It looks like from the same,
Yeah.
Yes, but all the same transaction. So right now. They reset it till September 9, 2026. And they gave him bond conditions for that one.
let's see what. Mr. Ruiz, as a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. Do you understand? I'm ordering you also as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. There's a protective order that has been issued in this case and you need to know it. If you do something to violate this protective order, they can file additional cases against you. A violation of protective order is the capital murder of misdemeanors. Do you understand, sir? Do not have contact with this person. I don't care what your excuse is. I don't care if you have kids with this person. I don't care if you have a zoo with this person. You do. It's not going to go well between us. You understand me? You mind printing out the MOA so I can put no contact, please? We are going to reset your case to give you time to hire a lawyer. I will have you sign a reset. I'm going to have you meet with pre-trial for your bond conditions, and then we're going to amend the bond condition or the order for protection to allow you not to have contact with this person. Great, great.
Apartments on it.
I can't talk to you. You need a lawyer, and then we can talk when you get a lawyer. But to this point,
I'm going back to my apartment.
I'm not. So I've amended it in two places, actually three. So the first one, no weapons, the case is closed, no contact. She put for some reason 60. Okay. All right, so let me have you go sign a reset. You'll get with Veronica for your pre-trial bond conditions, then you'll be on your way.
All right, Judge, next. Top of 16, Torres.
Mr. Torres, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
So, officer, what was the name?
Torres. Reckless driving.
On July 2nd, 2026, officers conducting surveillance on a group known for takeovers of public highways and parking lots. The group ended up in a parking lot and officer noticed a motor vehicle doing 3 or 4 donuts in a pit of around 70 to 80 vehicles and getting within 5 to 10 feet, striking the vehicles, forming the pit, and driving in the pit. The officer was able to perform a traffic stop of motor vehicle entering the driveway.
You didn't say that he was the one doing donuts. Did anyone see him doing donuts?
I believe the officer observed.
I believe. I need to know for sure. We don't work on hunches, so 100% I need to know, did someone see him doing donuts?
Yes, Judge, it does show that they were operating in full-marked vehicles in uniform and observed them performing donuts in their location.
You say them.
These groups would also meet in commercial parking lots, perform donuts amongst the crowd. We followed these parking around various locations and observed the movements of the actions of the group, including the black Chevrolet that is the pedal truck. Because the officers were doing these and like going to these meetups where they were going with their uniform.
But did they specifically see him doing
Yes,
it?
sir. They observed, and in this group activity, they observed the black Chevrolet Silverado belongs to this defendant doing the 3 to 4 donut pits.
Okay. Mr. Torres, I'm going to find that there's probable cause to go forward with your case. Does he have a license to drive?
Pulling that up right now,
Please.
Judge. I believe, no, Texas, there might be one out of Nebraska, it just doesn't give me the information. It says valid, that is all I can see from Nebraska.
Mr. Torres, I'm going to find that there's probable cause to go forward with your case. You're not to participate in these types of activities again. If I find that you do, first, I'm going to put you in jail, and then next, I will take your ability to drive away from you. You understand me? No reckless driving, no donuts, street takeovers, racing, anything of this nature. You are not allowed to drive unless you have a valid license and liability insurance in your name. You must have car insurance. If you don't have it, then no driving. That is also a condition of your bond. Do you understand, sir?
Yes, sir.
How do you support yourself, Mr. Torres?
I do steel erection. And
So you're currently employed full-time.
yeah,
Okay, what kind of money do you make a month?
I make around 35 to 4 grand a month.
Okay, we are going to reset your case to give you time to hire a lawyer. I'll have you go sign a reset. I'm going to have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go, sir. Please.
Conditions on them.
Thanks.
All right, Judge, bottom of 18, Williams, come on up.
Ms. Williams with you. You don't have to wait. You can come sooner, really. I mean, you don't have to wait. You jump up the line. Good morning, Ms. Williams. Ma'am, you're charged with driving while intoxicated is elevated to a Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On July 3rd, 2026, at 2:20 in the morning, officer observed a dark SUV fail to stop at a designated point in the 6200 block of Buffalo Speedway facing southbound. The vehicle stopped in the intersection of Buffalo Speedway and University Boulevard. The officer initiated a traffic stop in the 6500 block of Buffalo Speedway, and the vehicle came to a stop near the 6700 block of the block of Rutgers. Upon making contact with the driver of the vehicle, the defendant noticed a slurred speech, glassy eyes, and an unfocused gaze. He also noticed an open container of alcohol on the passenger floorboard of the vehicle behind the passenger's feet. The officer instructed defendant Williams to exit the vehicle and observed Williams to be unsteady on her feet and couldn't keep balance. He also observed her swaying. Officer asked defendant Williams if she had eaten, and she stated that she had consumed some chicken and fries. While speaking with the defendant, officer noticed a moderate odor of alcohol on her breath. The defendant stated she consumed one mixed drink and one shot at a club, and her last drink was approximately an hour prior to the traffic stop. The defendant believed that she's not on any medication, does not have injuries preventing her from walking, and also denied head trauma. The officer conducted SFSBs, and they were 4 out of 6 for the HGM, 6 out of 8 for the walk and turn, and 2 out of 4 for the one night stand. The officer read the DSC and requested a breath specimen. Both came back 0.205 and 0.192.
Wow. What was the stop for again? What did you say?
She was parked in the intersection. She,
Just moving, stopped in a moving lane of traffic?
yeah, the dark SUV failed to stop at a designated point.
Oh, okay, failed
Blocked,
stop.
and the vehicle stop also
Got it.
stopped in the intersection of Buffalo Speedway and University Boulevard. So,
Okay. Ms. Williams, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using alcohol or illegal drugs, and you will be arrested, you will go into custody. I will revoke your bond. I'm now also ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. You will have a blow device that's placed on your car. You're not allowed to drive any vehicle that doesn't have one. If you do, you're in violation of your bond conditions and it can be revoked. Do you understand, ma'am? We are going to reset your case to give you guys time to work it out. So we'll just have you sign a reset. You'll meet with Veronica for your bond conditions. And after that, you guys are free to go.
Yeah.
Like,
To trial intervention, coming out with the assessments.
it's up to you. I don't know. Why don't you talk to Karina first, just out of an abundance of caution? Because there's a fee and I don't want her just to, because I don't know what happened. There's no accident, right?
there's not.
But
Well,
the,
it is advised from that based on the BAC and based on no accident, no history, that she will most likely be attended with an 18-month PTI.
you saw it was,
Yeah.
okay.
No mitigation package because there's no crash, so I usually don't require one. Only
Even with the blow as high?
We have tiers based on. the
So, okay,
flow.
so it's still within the tier.
Correct.
Okay, it's up to you. If you want to, then yay. It's really whatever you'd like to do.
That way, it's sort of.
Sure, okay.
Thank you.
Sure, but do not use alcohol, do not use illegal drugs. I don't care about excuses. I don't care about this or that or mouthwash this. It's just not going to work. Do you understand?
Yeah,
All right, come on. Thanks.
All right, Judge, next is page 19, Simon Williams.
All right, you were, Mr. Williams. Sir, you're charged with 2 cases. You're charged with Class A theft. You're facing up to a year in jail and or a $4,000 fine. And on the terroristic threat, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. It also looks like you're charged with assault bodily injury. So it's 3 cases.
On June 27th of 2026 in Harris County, Texas, officer dispatched the 3805 Uruguay Drive in regards to an assault. The officer made contact with the complaining witness who stated the defendant exchanged words with her after she attempted to pass his motor vehicle. Defendant exited his motor vehicle and told the complaining witness he was going to beat her up and stuck his head and arms in her motor vehicle. The complaining witness attempted to exit her vehicle and the defendant slammed the door onto the complainant's legs, causing pain. Then witness then states the defendant struck the left side of her cheek and eye with an open hand palm slap, causing pain. The complaining witness $800 glasses were damaged and when he slapped her. When the defendant slapped her. The defendant then used his car door to strike the complainant 3 times in the legs and body, causing pain. The defendant was ID'd through Texas driver's license and the complaining witness. I don't know about that. I could double check about that.
About which one?
The theft.
And the terroristic threat. I mean, I get it for the assault, but
Mhm.
it looks like it's all out of the same transaction.
Yeah.
Is that right?
Let me.
Do you heart?
The theft, it says here, did then and there unlawfully appropriate by acquiring and otherwise exercising control over property, namely prescription glasses owned by the plaintiff witness, at least value, with intent to deprive the complainant of property. For real?
Good, yes, so it looks like he slapped her, the prescription glasses, the Oakley's value at $800 were damaged.
That's not a theft.
And I agree with that, Judge.
Yeah, mischief, theft.
He slapped her multiple times.
So tell me about the terroristic threat as well. I don't think I. Guys, no talking in the box, please,
Preston?
unless,
It was judged when the defendant exited, the vehicle, she attempted to pass the vehicle and he started to tell her he was gonna beat her up as he, struck his hand and arms into the defendant's, yeah, defendant exited his vehicle and told the complainant that he was going to beat her up. As he stuck his head and arms out into his open driver's side window,
okay,
and that's what caused me to be in fear.
got it. Okay. All right, Mr. Williams, I'm going to find that there's probable cause to go forward on the assault and on the terroristic threat, but I'm going to find no probable cause on the theft case.
And I will dismiss the theft case, Judge.
As a condition of your bond, you're ordered not to have any contact with the complaining witness in this case and not to be in possession of any weapons. No more road rage incidents. I tell you what, just a little self-control goes a long way. How many people are in our jails because they just really, you know what I mean? It's just not worth it, man. So what I'm going to do is we're going to give you time to hire a lawyer. I'll have you sign a reset. I'm going to have you take a seat while we get your bond conditions. Once you sign, at that point, you'll be free to go. Please.
All right, Judge, next is page 20. Wilson, come on up.
Hey, Karina, so no contact weapons with the complaining witness, please. It's,
The second, Wilson, the second case should already be signed. Page 20.
okay, this is Wilson.
The other one landed at court 9 for some reason.
Got it. Okay. All right, you were Mr. Wilson. Sir, you're charged with two cases. You're charged with assault of a family member. You were also charged with interference with the emergency request for assistance. On both of those cases, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officer was dispatched to Wash area, 16282 Imperial Valley Drive in Harris County, Texas. Upon making contact, the defendant witness said that the defendant was her ex-boyfriend. The defendant witness stated she was at home of the same address when her and the defendant got into a verbal altercation. The defendant witness stated she told the defendant that he was a bad father and he didn't know how to be a good father, which made him upset. The complaining witness started arguing. While arguing, she told him, the defendant witness stated while arguing, she told him she was going to call the police and that since the pair had made call previously to 911, the defendant took the comment seriously and headbutted her and took her phone. The complaining witness stated she pushed the defendant and tried to take her phone back, but he pushed her back. The complaining witness stated while in the squatting position, the defendant hit the complaining witness's knee with the phone. The complaining witness stated she observed the defendant about to leave, so she asked for her phone back multiple times, but the defendant took her phone and left the apartment. The complaining witness stated she walked to the washing area and asked someone to call the police. The complainant stated she felt pain from the incident. When the officer asked the defendant about the complaining witness's phone, it was already in his hands. The officer took custody of the phone and gave the phone back to the complainant.
Okay, so she did attempt to call the 911.
She did it.
Yeah, okay. Mr. Wilson, I'm going to find that there's probable cause to go forward with your case. You were ordered as a condition not to have any contact with this person whatsoever, not to be in possession of any weapons. There is a protective order and you need to get to know it. If you violate the protective order, they can file additional cases against you, and a VPO is one of the worst cases that you can pick up here. You understand? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset. I'm going to have you take a seat while we get your bond conditions ready. Once you sign them, at that point, you'll be free to go. When I mean no contact, I mean no contact of any kind. I don't care if she reaches out to you. She calls you, hang up. If she texts you, don't reply. If you have any kind of contact with her, you will the one that could possibly go back into custody. You understand? All right.
Your Honor, I believe that she said she was gonna call 911 and we took her phone. I don't know if she actually started to call 911.
Okay, that's fine, as long as she's, okay. I don't mind printing out the 2-second amendment.
All right, Judge, top of 7, Davis and co-defendant Felton.
Hey. Victoria, how many more? What? All right, ladies, both of you are charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On July 5th, 2026 in Harris County, Texas, in the officer dispatch in regards to HPD officer Gamal working an extra job, had arrested 2 females for shoplifting. When the officer arrived at the scene and was met with Officer Gamal stated that he received a phone call from the Lululemon at 2560 University Boulevard in Houston, Harris County, Texas, in regards to the shoplifters, and in regards to the shoplifters who just stole and is on the way to the listed address above. Officer was advised of what the defendants looked like and the items that were stolen, and had a tracker that showed to be inside a Lululemon store on Westheimer Road. Officer then observed the 2 defendants inside the store and began to make his approach when the defendant spotted him, threw the clothes in a dressing room and attempted to elude him, but he was able to arrest both defendants. The officer asked the defendants for the stolen clothes from the Lululemon. Were the stolen clothes from the Lululemon on University Boulevard? He asked where they are, sorry. And he was given verbal consent to retrieve the clothes from their vehicle. The officer then spoke to the complaining witness, who he finds credible, and who is the manager of the Lululemon. The complaining witness stated she recovered the items from the defendant and their tags were ripped off. The complainant stated that the dollar amount of items that the defendant attempted to take was $260. Complainant is willing to pursue charges. There's a second complainant, Lululemon at 2560 Harris County, Texas. And in regards, he had called Officer Gamal in regards to the theft and track the defendant's the tracker. The defendant stated that the defendant stole $580 worth of merchandise from the store and passed all points of sale. Complainant two was willing to pursue charges as well.
So there are multiple instances there.
Yeah, it looks like.
Yeah,
it was a-
the aggregate theft then. Okay, ladies, I'm going to find that there are sufficient probable cause to go forward with your cases as conditions of your bond. You are not allowed to go to any Lululemon whatsoever. If I find that you do, if you pick up a new case, I will revoke your bond and put you in jail. No more PR bonds for each of you if you violate these conditions or pick up new cases. Do each of you understand?
Yes.
Okay, you are Miss Davis. Who's Miss Davis? Miss Davis, how do you support yourself now? Okay. Are you actually employed teaching at the moment?
Yeah, I don't understand.
Okay. Did you want to apply for a court-appointed lawyer?
Yes, sir.
Okay. Deputy Williams will give you an application. And ma'am, how do you support yourself?
People turn around when I have work for me.
Are you working at the present time?
Yes, sir.
And what kind of money do you make a month?
Not much that I have bills, so.
That doesn't, how much do you make a month?
I say 1,500.
Okay. Did you want to apply for an appointed lawyer as well, ma'am?
Yes, sir.
Okay, Deputy Williams will give each of you applications. I need to know everything about you, how much money you're making, what kind of household income you have. So if you guys are married, whoever else makes money in the household, I need to know it. Please be honest. You guys will both be swearing to it. Do not leave until each of you sign the bond conditions, promising us you will not go to any Lululemon. All right?
Yeah.
Please.
I don't know if it matters, but it was two different Lululemon stores.
Yeah. No going to any Lululemon. Yeah.
This is the first. Yes.
Torres?
Is it your bond commission coming inside?
Counsel
for reset?
There was a case earlier where it was the guy driving with the fake license plate and the girl who claimed that the marijuana was hers. Just wanted to make sure that there didn't want conversations on that for the girl.
Do you remember, what was the last name?
Velasquez.
I didn't put any conditions on Velasquez. Yeah, okay.
Could I also verify, on Castro, that she is using an English option?
I didn't.
You did it?
No.
They were now?
Yeah. Okay, are you ready?
Yes.
Hey, what's up?
Hi, Judge.
Hey, good morning.
I'm here on a for office, Judge. He's here on an alleged bond violation. Especially the pre-trial officer.
Okay,
So my client is getting a work order because the machine that he's using is not working properly. Okay? Every time he's blown negative. Is there some?
I'm showing he failed to follow he's got 6 skips though.
But no,
He has 6 skips, 3 of them are outside of the window, he's a minute or 2 late for those 3. And I did verify that his device is malfunctioning. In regards to if that is what's causing the miss, we can't verify that because
So
they haven't determined what's wrong with the machine yet.
we need to know. I mean, I'm not going to take his word for it that if the thing's broken, this is a second bond violation.
I can show you this on the. Judge,
I need them to inspect it though.
and this is really his first bond violation. The other one was, he was incarcerated in another location. And, but it's not, that's the only bond violation he has, but there is, if he's got a work order, he's gonna.
He tested positive. I know that
No,
was
he never
18. It was an 18.
Every one of his blows has been negative. And ever since this, he's taking
So-
videos of every time he blows and he's been negative every time.
Judge 149, did test positive for THC.
But it looks like, was that an 18?
I'm not sure if it was a typo that it was 2018 or why it says 2018.
Was this, yeah, I mean, it says
But
that
he wasn't arrested for people. I don't know what's going on.
what does that mean, Veronica? What I'm gonna do, I'm putting a scram on him. I mean, he's got three skips at least. He's not in compliance with the time
But
limit.
they're not skips, Judge, that's the thing. They showed him, like, I know you don't have the time right now, but I can show you where he opens up the box, the blow, and it doesn't show anything. And
We have a total of 6 total skips, right?
no,
3 are outside the window. And then we have another 3.
but and outside the window, we're talking about 2 minutes. You know, we're not talking about hours after, and he's blown every time, it's been negative. There's nothing positive whatsoever.
What about the other 3
In
skips?
the UA, it's just the standard to show the UA history from before, so those.
Okay, so it's nothing recent.
On his current case, we only have 2 drug tests, which are from May 27th and June 12th. And the May 27th was a no-show, which was negative.
The May 27th week, that's when he was.
Sure. But what about the other 3 missed tests?
The other thing is just for full, like, missed flows, we don't have any data from the missed test, and we can't verify because of the.
We've got the data showing that he opened the machine up. We've got data, he's taking videos every time he blows now.
So let's send him to pretrial so he can tell them what's going on. So they
Yeah.
can inspect it to see what's wrong, if anything, and he can show them whatever data he has and we'll go from there.
Okay,
I mean, they're the ones who expect everything. I'm not gonna take his word for it, but he can talk to them, explain to them what happened. They can take a look at the machine, see what's wrong with it and formulate a conclusion. We'll go from there. So if you want to go send him now, we'll get everything done now.
thanks, Judge.
We can inspect the device at pretrial services, we have to send it to the Intoxil company and they get the device.
Well, he's seen an new device already because
In the interim, I'm putting a scram on him, so I know that he's not going to have any issues. And then once we get all that back, if there's no issues, then I'll take the scram
when
on.
he gets a new device. Okay.
Yeah, so for now, put the scram on and then send whatever you need to so we can get it, so we know.
When
Okay,
he gets a new device, then we'll let you know.
but I want to know about those 3 missed blows. I want to know what happened. Are they true violations?
I know you don't have time, but I can show you that they're not
Yeah,
violent.
I don't, right. That's why we have pretrial to look at everything and to digest, and I just don't, right, I don't. And then I still have to go to court 6 and do all their arraignments too.
That's fine,
So,
I'll let you go.
Judge,
Hey.
good morning. Judge, we had come in on Monday on Noah Scott. You had ordered Mr. Scott to get an interlock device. After he left, he's been using his grandparents' vehicle. And they found out that he was gonna have to get the device. They said, "Why don't you use the vehicle anymore?" And he's been removed from their insurance. I wanted to see if you would allow him to get a portable device and sign non-driving after that.
What car was he driving when he picked up the DVI? Huh?
He was driving their vehicle. And they said no.
But how do I know that they're still not going to let him? How do I know he's just not going to go take it? That's the problem. When you have a vehicle accessible and there are keys on the table, it's very easy to pick up the keys. Oh, you know what? I got to go get smoked.
They were pretty upset. It was on everything, and they found out that
Right.
they're gonna be-
Time heals all wounds though, you know?
I just, he's pointing to he's, that's why he called us yesterday, hey, this, that, he didn't want to break the rules, they wanted to make sure he was compliant.
He's
That's why he's here.
he's driving without an interlock. He's already breaking the rule. What's your cause number, please?
Yeah, cause number, Judge, is 2627526.
All right, we'll put a scram on him and scram. Just let Veronica know and we'll waive the signature.
No, Judge, she's here. Judge, she's here.
All right, okay. Mr. Scott, come up. I hope that you take this seriously. You're not allowed to drive. There's nothing in this life that you can justify. I don't give a rat's behind if someone has to go to the freaking hospital because they're having a heart attack. You still cannot drive. Do you understand?
Yes, Your Honor.
No means no. Okay, thanks. Hey, people think it's not a big deal, you know, I was every single day. So properly admonished. Yeah, okay, tell me, what's the word?
I'm in here on the veto check. It seems like a speech has been completed and this case has been dismissed.
You signed it already.
Okay, you're done. We signed it. Yeah, thanks.
I was sent him home.
Yeah, does he have an interlock or anything like that? Does he need a removal?
I asked, but I'll be there.
Okay,
Let me find out. Because, thank you.
hey, I'm gonna go to, can I go to 10 or 6? Yeah. Is there anything I haven't signed? I don't remember what the hell was I doing. I think, except for that, I'm gonna do it right now. Damn you. Okay, come on, bring it.
Page 17, Valdez, come on up.
Did you say page 17? You are Mr. Valdez. Mr. Valdez, you're charged with 2 cases. You're charged with evading arrested detention and disorderly conduct. It looks like discharging or displaying a firearm. You're facing up to 6 months in jail on the disorderly conduct and up to a year on the evading. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 3rd, 2026, at 1 a.m. in Harris County, Texas, plainclothes officers were investigating street takeover groups in the parking lot. The officers observed the defendant, the back left passenger of the motor vehicle, pointing a shotgun in the air with people in close proximity. The officers conducted a traffic stop, but the back left passenger jumped out and ignored commands to stop. The defendant evaded for 250 yards, but was eventually detained. The defendant stated he owned a shotgun.
Do they see him with the shotgun? Someone saw specifically him?
Yes, it says, officers observed the back of the passenger to Dodge. He was later identified as defendant Valdez.
Okay. Mr. Valdez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons whatsoever. If I find that you do, if you pick up a new case, I will revoke your bond and put you in jail. There'll be no more PR bonds for you. Do you understand? This is not a revolving door. How old are you, sir?
17.
Okay. You want a court-appointed lawyer? Do you want a court-appointed lawyer? You want to hire a lawyer? Okay. We're going to have bond conditions created for you to sign. Do not leave until you sign them. Victoria,
Yes, Judge.
THA for Mr. Valdez, states bond conditions.
Okay.
Do you mind filing no weapons?
Well, no weapon search for Valdez.
Yeah,
That's it, Judge.
please. All right.
And then people had it arranged.
Yeah, I'm letting him in now. Okay. This way, we're gonna have you sign a receipt and then we'll have you take a seat in the jury box. Abel,
Judge, good morning.
I don't get that. Oh,
Aren't you from Argentina?
I can't see.
Oh, it's Argentinian.
But
Anyways,
that's not, is that today? No.
tomorrow.
Yeah. What's today? At 2:00, right?
It's Spain against someone.
Yeah, right when nobody can watch it at 2:00. Why the
Right.
hell do they do that, man? What's wrong with them? Put FIFA on probation, man.
We should.
Big screen in your office. Varsity.
This is the office. I guess that's a big screen.
You never watch it.
All right, Abel, who you got, man?
I got Mr. Mongoor, Brandon Mongoor, Monghur.
All right, coming up, Bonjour. So, Karina,
Yes, sir.
is discovery complete on Mr. Monjour?
I'm checking that right now, Judge. All right, but the only thing that we're missing is we haven't been able to get a hold of the complainant. Our investigator is on it, and we also have a to-do to eval without the complainant.
So
It's the only thing we're missing.
it's time. I mean, really, the case is 250 days old. You guys, one setting, right?
Yes.
And Mr. Monjour, you're charged with assault, bodily injury. As a condition of your bond, you're not to have any contact with the complaining witness, not to be in possession of any weapons. Your case is 250 days old, and I'm fast tracking you to trial. At the next setting, it would probably behoove you to meet with your lawyer to figure out what evidence is out there. Because at the next setting, you must accept the plea bargain agreement, or I will set your case to trial, and I will not accept anything after that. This is your plea bargain deadline. You have 3 weeks. You will be back here to either accept or reject the plea bargain. Do you understand?
Excuse me. My attorney, I've been trying to get in touch with him, like I emailed him, but it's just ain't.
I'm sorry, what?
I emailed my attorney, like when I first.
So here's we're going to give you a reset document now. On that, it'll have his phone number. You need to call him today so you guys can formulate a plan. Just be on the lookout for him calling you. Do you have a cell phone now?
Yes, sir.
Okay. Abel, we're going to have him reach out to you here momentarily after we give him the reset. Okay? 3 weeks.
Please and thank you.
Hey, you want to give me a date? Please. What's the problem? What?
The first one
You come to court when you want to come to court. You don't come when you're ordered to come to court, and that's a problem. Stop. We have dates, so that way when you come, he can be here. You come when you want to come, and that's not the way it works over here. Do you understand? So the next time, it'll be 3 weeks. If you were not here, I'm going to revoke your bond, and I'm going to go bananas on it, and it's going to go high. Do you understand? There will be no more PR bonds for you.
Judge, how's August 4th or the 6th?
Can it be, I'm not here that week. Can it be the 7th of that week or the week after?
7th? You say 7th?
Yeah, August 7th.
That's Friday.
Any day but Friday, Abel.
I can't that week or the week before, but I could do that Friday or the 10th.
Do the following Monday. Sure. How about the following Monday?
The 10th, August 10th, yes.
Okay. That's a required appearance, and that's clear trial on that setting, Abel, okay?
Yes, sir.
All right, man.
Judge,
All right,
if you could, the reason I was not able to get a hold of him because he didn't have a cell phone number. I was communicating through his mom and his grandmother. So if you could write down a way to
Okay,
contact
hold
him.
on. Hey, do me a solid. Can you get his phone number on his cell phone, please, so we can text it to Abel, so there's no excuse, please? All right, Abel, I'm efforting
Thank you, Judge.
for sure.
Have a good day.
Don't leave yet. Wait, don't leave. I'm going to chat you the phone number.
Oh.
Hold on. Calmate, che.
You're Argentinian, aren't you? Aren't you from Argentina?
No, man, come on. Don't insult me.
Paraguay?
I'm kidding, but no. Chile.
There you go. Y'all are neighbors.
Chilango.
Judge, are there any conditions for him to sign today?
Does he already have conditions in place, guys? You know?
I think he did, Judge. And then, yes, and I saw a note that no contact with the complainant on 11/13.
So we still got it.
Yeah, these are conditions for the magistrate.
Okay. Yeah, leave it. Whatever the magistrate put stays.
Williams?
Okay, yeah, we're good.
Okay, good.
Hey, real quick, because I gotta go to 6 room.
Jen, yes, this is, gonna be about Charles next week.
Okay?
So, I'm not sure if the court was aware that next week is also baby DA school week.
Okay,
So we have a few cases on docket, Chantia, I asked the court knows I am also in trial, still in felony court, so they don't have a chief. And then Chantia is out on the $15 waive to like the week after that. And so it's time to figure out scheduling wise. So we want to know if the court was gonna go to trial last week at all, so we know about how to find coverage.
yeah, I mean, we don't have any VAs though. Who are we gonna have covering? I mean, you're in trial and then Chuck is on too. So who,
That's what I'm trying to figure out.
Yeah, we can't-
Covering docket wise, yes, we can do that. I was just wondering for trial wise.
it'll be too hard to go to trial. I mean, yeah, you're gone and then she's gone, just, it'll be impossible.
What about an intern, Judge?
They still need someone to supervise.
It'll have to be 3 years or older. which one's it?
No, and then you need, for an intern to try, because at least 2, they gotta be in second year at least. Right? Do you have a bar card?
He has a bar card, but I have to supervise him.
Sure.
It has to be over 3 years, prosecutor to supervise them.
So what you're saying is the 20th is the earliest that we can get it.
The week after would be, yes, Judge, would be okay.
Wait, so the week of the 27th.
So she's gonna correct, because she is gone from the 15th to the 20th.
Do we have anything on the 28th? Do you know?
I'm pulling up the trial
Let
document.
me see.
We have on the 21st.
Judge, you're out that week,
Why am I out?
you know.
Judicial conference.
I'll skip it, man. I'll skip it.
No, you can't.
Yeah, it's fine. I'll give it up. I'll call him and I'll give it up. What do you say to the 28th? Are you cool with
I
that?
really, really like that previous trial date, especially in the interest of justice. Fine, but
So, well, look, I'll give this to you. So if you're okay with the 28th, we can put on the 28th. In the event that they're not ready, we're going regardless. It don't matter.
And Judge, we were ready for trial, because this was one that Sean had kept, previously he was gonna try, but because he got promoted to felony, that's why he's no longer able to try it, is there like, yeah, because he was in it, this one. that-
Right, but we keep having, there's
Yes.
always,
But
right,
I wanted the court to know that we
Sure.
are ready for it, it's just unavailability issues, that's the only problem.
get it.
Yeah.
Well, week of the 27th,
Yes.
but
Judge.
that's the final,
Yes,
like,
Judge,
if
and we can-
no more
that's what-
continuance.
Judge, which case is this that we're talking about?
The animal cruelty case that we've
That is
been,
correct, Judge.
that we've been waiting on.
Jones.
Yeah, right. Are you okay with the 20?
Jones?
yes, sir. So we pick on the
Yes.
28th trial on the 29th.
Right,
Yes,
you're right.
sir.
Yeah,
So Jones needs to be moved to the 28th,
Yes, ma'am.
7/28?
yeah.
Okay,
Judge, did you just, do you want, should we send an email to all the ones that next week for the same thing?
Yeah.
Just roll into that week.
Yeah.
That's all we have, Your Honor.
Okay, man. Have a great weekend. Yeah,
Thanks.
all right. Thanks, Ramona.
you're welcome, Judge.
Hey, Ralph, you wanna come up here and sit something?
Whatever, one doesn't. Miss Jackson?
So it's transfer.
Okay, that's our website. Not yet. I guess, I mean,
They just want to talk about it.
oh, there, it is a whole file.
No, like, yes, they
Transfer it. But does it, like, full file?
No.
Ms. Sanchez? Yes. You can go back. Ms. Quiroz? I told him I was trying to read until I died. Oh, yeah. Oh, yeah. Miss Felton? I didn't. That's so much. Yeah. Always a little bit, they see the answer. And he's lying. Yes. Miss Davis?
So we went. Yeah.
You go to jail on 5 days, whatever, somebody will see if all this in jail.
Yes. Yes, is it the same number that's in there?
That's like everyone's like obviously that's what the families are. So like we're fine. Yeah. So like we go, we're there.
We had a.
Okay,
Way easier on my phone. Maybe it's probably not. Yeah, like, big, like, I feel like the SEC didn't, that's the first time.
It says Monday.
How are you doing? But also, we're with the college.
Yeah. You know, where my news and I.
Especially.
Yeah. You guys.
Yeah. The quarterback.
Yeah.
One of those good ones. That's practice. I love
So, yeah. Yeah, it's gonna take.
Never fails to finish Oh.
Yeah.
What?
Yeah, I feel like, there was so much I could do.
I would do it again. I wanted to try to. I'll be here. I also. Yeah. All right. I like pen. Yes.
Oh.
It's gonna longer be.
It's not just anyway. People who feel like I so sneaky.
So, yeah. So like. West. But yeah. Like me, I'll, my gym like 2 minutes, 2 minutes, everything's supposed to be. Yeah. It's kind of weird. I was like, yeah. Wow, you can explain that. The first one. I'm on the way down. You are? Yeah. You saying? Yeah, it's like a small. Yeah. Maybe. The one thing I would say is
Oh, sure. It might let a bunch of folks out of jail.
Yes, Why don't you guys still ask us? Why don't you just it's just your stuff. Number 8. If you need to, just let me know which one. The biggest problem is like the
not, and we actually like, so like, living charity.
Yeah. I've never seen you before. You don't.
Karina. Hi, I'm Wilson, Jacoby Wilson. I'm waiting on the bond conditions to come. If you didn't put his name, okay? So he waited. Oh, okay. Less than 5 minutes ago? Oh, okay. It's you forgot to miss it. Gotcha.
And we can do that when we get there.
Man, I did nothing over there. Hey Herman, what's up, buddy?
Good morning, Judge. I'm here for two trial cases. You're blank, your screen's blank, it's darkened. I don't know if you got that purposely.
So you have the trial case,
Two.
one of the trial cases for next week, two of them.
Two. Yes, sir.
So it's baby DA school next week,
Yes,
and
sir.
our Karina is in trial as well. So we really don't have the manpower to do it. So
Sure, Judge. I was hoping I came earlier this week on one of the trial cases that he decided he wants PTI, if you would consider
I'm
that.
okay. All right. If you want it, then go for it. But let's do it quick.
Yes, that's Richard Rodriguez. I also have Sylvester Carroll set for trial.
Tell me, what do you want to do with him? Do you want to keep him on the trial docket?
Yes, he wants to stay on the.
Okay.
Yes.
So for now, we set it on the 28th of July.
Okay.
But if you want to go a little bit further into August, I'm okay with it.
That'll be. I just have vacation the 7th through 14th. So if it can be done before the 7th or after the 14th. or after the 14th. That would be great.
Yeah, I would say let's probably do it after the 14th then. How about the
Thank
18th?
you. Yes, sir. That'll be great.
Okay, are you okay?
Judge, for, Mr. Rodriguez, he would be approved for the 1 year PTI. I put in the offer. I see here already submitted the application, so he just needs his client to get a TRAS done.
So can you bring your client next week to come do a TRAS?
Yes, I'll bring them in Tuesday as scheduled, if that's okay with you.
Yep, we're good with that.
And then Sylvester Carroll reset to August 18th.
Yep.
Yes, he'll be reset.
Okay, thank you very much, everyone.
Okay, thanks, Herman.
Thank you. Bye-bye.
Take care. Mr. Leonard. Hi. Hey.
I'm here on one of the trial cases as well. I did hear the court's conversation. I would, however, like to re-urge my motion for speedy trial on this. case.
Oh, yes, yeah, but I don't have a DA. You want to do the week after? You want to do the week after?
If we can do the week after, as soon as possible.
What do you, what,
That's fine, Judge. You should work on, we can do the week after and we'll figure out, at least I'll give you a week to find coverage and someone to look at the case and
okay,
find coverage for it. Yeah.
I appreciate it. Would it be that next Tuesday?
Tuesday.
Okay, thank you very much.
Tuesday.
Judge. Tuesday. Tuesday.
Hey,
Good morning, Your Honor.
have you been? It's been a while.
I know, Judge, I'm in floor
Right.
8 now, so
In what?
in floor 8,
Oh, floor 8, got it. Okay.
but I'm here on another on trial case that's up next week.
Oh, okay. So you want to go into August? You want to go, you tell me what's,
28.
we currently have you set for the 28th, but if you want to do something different, then,
I mean, it's 20 years looking good.
well, how many other,
We don't have anything on the 28th. But we
well,
have,
I thought we have the animal cruelty cases on that.
oh yeah, we
day.
did move the animal cruelty case to that day.
That dude's pressed that, I think,
That.
right?
So, yeah,
So
Yes, he is.
do you want to, and but he's bond forfeited before. So should we keep it maybe on the 28th, just out of an
That's fine.
abundance?
It's an
And then
interference, It's not gonna be like a too long of a pace.
if we do go, then we'll reset you, but out of an abundance, because he's
Yeah. probably.
not shown before. So, okay, so we'll leave her on the 28th for now.
Well, it's not on the 28th, it's on the 14th. And I have a question. So Martinez needs to be reset to the 21st?
That's Cole's case.
Oh, yeah,
Yeah.
yeah.
Okay, got
Yes,
it. Okay, thank you.
okay.
And then Amador, we're gonna move it to the 28th.
Yes.
I got it.
I need a nap.
Wait a little bit, I'll look at it. Okay. I can go.
Hi, Sebastian. Hey,
On the, he's got a BDR.
how are you gonna get fired on your day off, man? You got a BVR in jail?
No, he was, I think he bonded out on 2 misdemeanors and then. If you look at his history. he
I'm
has
just
no
kidding, I'm
history.
just kidding. I mean, we'll just continue. I mean, there's nothing really to do. He's in custody. He's got like 5 open cases,
Just
so
keep the.
we'll just keep it as is.
I don't know.
Yeah.
Yeah.
Ooh. No, I missed the 2 prior cases that he's on bond for.
Right, that's what I'm saying is that.
Got it.
those-
All right, I'm so sorry. So
What I'm saying
on
is
the
that-
harassment and on the assault, I'll set it at 1, 2, 3, 4, 5, 5,005 each.
So, just, my only request would be that he is actually trying to put money together. If you look at his history, he doesn't have anything up until now, when he's, in his 60s. Clearly, there's something.
Great.
on.
He's still on 1, 2, 3. So that's 3 cases with us. He picks up 2 felonies and then he picks up 2 more cases with us. No. Sorry,
So it's 5,000.
5, yeah.
5 on both.
On both, yeah. So guys, on the harassment and then the assault, yeah. And then I'll do bail order street for, hey, you want to talk about something?
Yes, we have a couple more arrangements. Is she still on there?
No, she, Hold on, let me see. No, she took off. She was here for about a minute.
She's been checking in on somebody all day. Okay, Judge, the arraignment, page 14, Nancy, Diaz,
Take care.
You said page 14.
Judge Bottom.
What time did this gentleman get here?
This is the one that Echelon messed up and didn't tell me he was here.
Santibanez?
Yes, Judge.
Did he get here on time?
Yes, Judge. Yes.
He did?
Yes.
Mr. Santibanez, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay. Boy, 2025 and 2026 has not been a good year.
Mr. Simon.
Santibanez.
For both charges, Your Honor?
Both charges.
Oh.
Do you see more in one?
Wait, maybe I mixed it up. Oh, no, I'm sorry. That's my fault.
That's okay.
On July 2nd, 2026, law enforcement officer observed a motor vehicle with no front license plate in Harris County, Texas. After a traffic stop, the defendant had no insurance, and the defendant's license was not eligible, according to the law enforcement officer doing a search and interacting with the defendant. Do you need the license plate number?
No, well, they just pulled him over for not having a front license, right?
Yes, yes.
Okay. Mr. Santibanez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to drive. I don't care what you have to do in this life. If you drive, there are going to be grave consequences. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care that you have to go to work. I don't care that you have to go to school. I don't care that you need groceries. I don't care that you have to go to the hospital. You drive, I can have a contempt hearing every time, up to 180 days in jail and a $500 fine. Do you understand?
Sir.
We are going to reset your case to give you time to hire a lawyer. I'm going to have you come up here, swear to us that you're not going to drive, and then we're going to get you out of here. When you come back, please have a lawyer. Come on.
Also had our. Page 28, Martinez, come on up.
This is Mr. Martinez.
Yes, Judge.
Did he just get out of custody?
Yes, Judge, last week.
Mr. Martinez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On January 11th, 2026, in Harris County, Texas, law enforcement officer observed defendant's vehicle facing the wrong way in a moving lane of traffic with heavy damage to the front bumper. Bystanders waved down the law enforcement officer
and said that the defendant is trying to flee the scene. The law enforcement officer detained the defendant and upon making contact, observed a moderate odor of alcoholic beverage on the defendant's breath and person. The defendant had slurred speech, and the defendant admitted to drinking 2 beers. A legal witness stated that that prior to the defendant striking a pillar, the witness had been involved in a car accident with the defendant, where the defendant drove off without exchanging information before striking the pillar. Once striking the pillar, the legal witness observed the defendant get out of his vehicle while dragging his daughter, later identified as JM, alongside him. The standardized field sobriety tests were refused and a blood warrant was executed.
What do you mean drag the daughter?
It does not, that's just the phrase that's in the DIMS, Your Honor, dragging his daughter. It doesn't, give.
I'm going to order, so would it be prudent to order no contact with this person because he has also picked up a felony DWI with this child passenger as well?
The state is not asking for a no contact order with the minor, if that's what the court is asking.
Yeah.
Oh, no, the state's not asking for a no contact order with the minor. No, you're right.
Mr. Martinez, I am ordering you not to drive a vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what you have to do. Your case is 180 days old. We will give you one setting to determine what you want to do with this case. We put cases on the trial docket at 180 days. If you ever take off again, I will revoke your bond and I'm going to make it extremely high. Do you understand? We will give you 2 weeks to go hire a lawyer. When you come back, we will have someone sign on, and at that point, the next setting will be a trial setting. Do you understand me?
Yes, sir.
Okay. So 2-week THA. Do you mind filing bond conditions and no driving, please?
Yes, Your Honor. No driving?
Yep.
Yes, Your Honor.
All right, we were going to have you swear to us that you're not going to drive. I'm going to have you sign a receipt. We will have you take a seat while we get your bond conditions. Once you sign them, at that point, we'll give you time. When you come back, please have a lawyer. Any more arraignments? Guys, we're done.
Okay.
Thanks.
Good weekend.
You too. Have fun, guys. But we're not done yet.
Oh, dang.
Good try.
Yeah, you can't do that.
Oh,
Right?
man.
The lawyers that are,
Hoodwinked.
Right.
That is great. Oh, wow.
I think we're pretty close though. For what it's worth, we're pretty close. Right? No?
We're almost done, Judge.
Let's wait.
Judge, it was just about driving accident, right?
Yeah, that's fine.
Sorry.
Yeah, really.
Don't. You really want to go to jail? Yeah, you. Don't talk.
But it's not his case, so. Really?
Yeah, come on.
PVR
5001. I need to do a bail order too.
Valdez?
Okay, Victoria.
Bottom two, it's PBR, then I'm also
So no, okay, they didn't appear. Okay, 5002. Yeah.
Already?
Wilson?
That's mine.
Okay.
Bottom of three, step four, Raymond, three, not supposed to.
10,003.
And that's how
On the side.
Okay.
Next. Top of nine. Central Raymond, the defendant called and said his child had an appointment.
Had what?
His child had an appointment.
To what?
A doctor.
SFBF Monday.
The next one is. The last one, Judge, on page 14, he's here. We're just waiting on Andrea to go back on.
Schilling?
Everybody else? Okay. Yeah. Was it exciting?
Hey, you ready?
I'm ready. I'm gonna do it right now.
All right, we're waiting. Bye. Skilling, come up. You ready, Miss Ionescu?
Yes, I'm ready, Judge. I have my video off because I am not appropriately dressed for court. I'm on vacation.
That's okay. Well, I'm glad that you made it. Don't worry about it.
Thank you.
Mr. Schilling, you are on bond for an evading arrest, and you've now picked up a new case. You're charged with possession of a criminal instrument. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
For possession of a criminal instrument, correct?
Mhm.
Okay. On July 2nd in 2026 in Harris County, Texas, an officer observed the defendant who was ID'd by Texas driver's license riding a bike without lights. The officer stopped the defendant and the defendant was shown to have a warrant out for his arrest. The inventory search led to a screwdriver, pliers with wire cutters, a multi-tool, an arrow key, and a ski mask in the defendant's backpack.
What time of day or night was this, and why was he searched? Was
There
he
wasn't
under
any information
arrest?
About what time of day it was.
That's a problem, because riding a bike without a light has to be done at night. And on what basis do they get to the search? Was he under arrest?
Going to arrest him because he had an active warrant.
Oh, that's right. Okay,
And we pull up to see if I find the actual. We don't have the option for it.
that's a problem.
It doesn't say the time of the judgment.
Okay, I'm gonna find there's no probable cause to go forward with your case, Mr. Schilling. You know, we have enough property loss, we have enough death, dismemberment in Harris County as it is. Don't add to it. If you are a danger to my county, it's just really not gonna go well for you. Do you understand? There are no more PR bonds for you. Why don't you go out there and get a JOB? In fact, this is what we're going to do. I am now making that a condition of your bond, and I'm bringing you back in 2 weeks, and I want to see what you have done to get a job. If you have done nothing, it's not going to go well between us. I want to see somewhere to the tune of around 20 to 30 applications for a job. Do you understand me? You are not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. You will get tested next week at some point. Be ready. Do you understand me?
Discuss something else this week.
They're going to dismiss the criminal instrument case, Andrea.
Thank you, Judge.
Can I get a date? Give me 1 second. I need to get your date. 2 weeks, please.
2 weeks, Judge House, July 28th through the 30th.
I'm here all those days, Judge, so whatever works for everybody else.
Yeah, I don't care.
29.
All right,
That
29th
works.
it is. You must appear at that setting and you must show me what you have done to get a job. You must get a JOB. Do you understand? See you in 2 weeks. All right, thanks for coming back, Andrea.
Thank you, Judge. Have a good day.
Take care.
Bye.
Bye.
Yes. Yeah.
Judge, were there conditions on this one?
No. Oh, yeah. I'm sorry. I saw rounds come back. Does that mean that they're ready? Okay, are we good?
I don't think so. Yes, Judge, that's it. All right, go ahead and sign. Ron, are you ready? You're on the benches. Bottom 16? Yes, we did it.
Thank you. Yeah, go. Thank you for helping us. Guys, I think we're done too.
Thank you.
So, yeah, have a wonderful weekend and we'll see you Monday. Hold on, let me